Good afternoon. My name is Aleksandra Partyk. I'm a lawyer. I'm PhD. I live in Poland. At the moment I work at Andrzej Frycz-Modrzewski Krakow University as assistant professor. Besides, I'm a managing editor in the Studies in Law research papers. I would like to thank you very much for the possibility of presenting my topic here during the conference. My topic concerns Polish civil procedure and artificial intelligence. The topic is initializing proceeding in a civil case using AI selected commands regarding Polish civil procedure. More and more people are asking whether artificial intelligence has a bright future in the administration of justice. Various authors make an attempt to answer the tricky questions. They are considering whether it would be acceptable to make the functioning of the justice system more efficient using AI. We should be sure that in selected countries, legal steps have been initialized to make that idea come true. Asking about admissibility of using artificial intelligence in administrating broadly defined justice has its practical grounds. Lengthiness of proceeding is a problem common across all over the world, not only in Poland. In Poland, judges are remarkably overloaded with their professional duties. They are not only deciding on merit of the cases, but they also are undertaking several activities which are of technical nature. Taking into account the number of cases that a civil court judge on average examines annually, and the enormity of the number of activities other than judging is downright overwhelming. Whereas unlike human judges, whose work capacity over the course of 24 hours is limited, machines are able to work constantly without breaks. Therefore, it should be considered whether the solution to this problem would not be active involvement of the machine system in examination of civil cases, in limited scope at least. It seems plausible from technical perspective, but such a solution has to be confronted with the duty of the state to guarantee the execution of citizens' right to a fair trial. I would like to focus on the issue of the preliminary formal check of complaints in civil cases and the possibility of performing the procedural activities at the stage of proceedings by computers equipped with artificial intelligence. To start with, it's a cliché to say that not every complaint filed to a court will undergo examination by merits. Working at the court only for a short time is enough for one to realize how many pleadings suffer from significant shortcomings. Numerous failures, among them unclear formulation of the claim, lack of signature, lack of someone's address, prevent the court case from being moved forward. The Code of Civil Procedure contains very detailed regulations concerning the formal requirements of the complaint. For example, each pleading shall contain following data: name of the court to which it is addressed, forenames and surnames of the parties, the legal representative, the agents, the signature, the types of pleading, and many more other. Only a complaint that is correct from the formal perspective and which is properly paid can form a basis for further proceedings. If a complaint either does not meet formal requirements or the fee due has not been paid, it's necessary for the submitting party to be ordered to correct formal deficiencies. The failure to do so means that the complaint will be returned. The returned complaint is treated as not filed and does not result in any legal consequences. The formal check of complaint is a labor-intensive and time-consuming work. Therefore, taking away it from the judges, it meant that they would have time they could devote on other cases. Undoubtedly, a computer program would impartially and effectively verify whether a complaint has been properly formulated or whether it contains any flaws that impede examination of the case by the court. But the question remains, though, whether a soulless machine system could replace people performing justice functions with the administration of justice. The possibility of passing the execution of the administration of justice to machines arose opposition among representatives of both sides and practitioners of law. Regarding the possibility to give control over execution of administrative justice to machines, the problem of judiciary independence plays a fundamental role. Independence constitutes an essential element of judiciary. We may state that the body is not independent and it cannot be a court even if delivered judgments in a matter respecting all the regulations of law, if it's not independent. Whereas it's making decision in accordance with the judge's own consistence that constitute the essence of independence. Conscience is characteristic for humans, not for computers. But luckily, not every activity performed at the court is of judicial character, so it does not need to be regarded as element of judging. Undoubtedly, the formal check of complaint is just of such a nature. We should highlight that formal examination of complaint is technical in its nature, and although filing a complaint in court initializes a civil case, the formal check, however, is not yet a component of resolution of the case. The analysis of the complaint from the perspective of formal deficiency is not connected with the substantial evaluation of the claim included in the complaint. As performing procedural activities connected with examining the complaint from the perspective of formal requirements does not belong in the realm of administrative of justice in the strict sense. One can therefore assume that entrusting artificial intelligence with such activities will not constitute a breach of right to fair trial. Analysis performed by machine system would most probably turn out to be more accurate and faster than those done by humans. An automated system of formal verification of pleading would undoubtedly disburden judges, relieving them from tedious and time-consuming work. That would enable them to focus on other activities that truly require the involvement of the human factor. A procedural resolution of this kind would not only require specific changes to civil procedure regulation in Polish law, but also creating a great IT system and appropriate technical infrastructure. Maybe it will come to live one day in Poland. Thank you very much for your attention.